Hi there. Welcome to our webinar on self-advocacy in the workplace, Know Your Rights, from Disability Rights New Jersey. My name is Mike Murata. I'll be in the background of our webinar today, providing some technical support. So if you're joining us live, a couple of quick things for you. We are recording this, so you will get a link to the recording. There are also captions available if you need captions as we move through it. If you go down to your toolbar in Zoom, and select show subtitles, it will put the captions up on the screen for you so you have access to them. We also have the chat box, which is available. So if you'd like to post questions in there, Kathleen will address those at the end, I would guess, when we're done. And if you need any technical support as we go through the webinar, I am here in the background. Feel free to send me a private message in the chat box and we'll be all ready to go. And with that, I will turn it over to Kathleen and I will mute my microphone.
All right, excellent. Good afternoon, everyone. My name is Kathleen Redpath Perez, and I'm the managing attorney of the employment unit at Disability Rights New Jersey. I'm going to discuss a little bit about Disability Rights New Jersey. We are the designated protection and advocacy agency for New Jersey. We do advocate and advance the human, civil, and legal rights of residents in New Jersey. And I want to discuss some learning objectives with you. Looks like we skipped too far ahead, but the learning objectives for today are: what is the ADA? What is the New Jersey law against discrimination? How can you request a reasonable accommodation? And when, if ever, do you need to disclose your disability? So those are some things that we're promising that by the end of this presentation, you're going to have learned. So with that, this is the slide that you should have seen in a moment, but this is the Americans with Disabilities Act. And that is a federal law. It's a civil rights and, like I said, federal anti-discrimination law, and it provides and protects, among other things, the right to a reasonable accommodation for a qualified person with a disability. So we're going to break down that definition. And but first, we're going to talk about what rights you are entitled to under the ADA if your employer is covered. And that would be that the ADA says that an employer cannot discriminate against a qualified individual because of a disability when it comes to job application procedures, the hiring, advancement, or discharge of employees, and also employee compensation, job training, and other terms, conditions, and privileges of employment. Sorry, I'm trying to just show just my view, but that doesn't seem to be working, but I'll just make sure that you can see all the words on the screen. All right, so like I said, we're going to break down the definition of, just the ADA, just break down the definitions in that law. And, one of the terms in, the Americans with Disability Act is that it talks about a qualified person. And so who would be a qualified person? So a qualified person is a person who has a disability. It includes people with intellectual and developmental disabilities. And it is someone who, with or without a reasonable accommodation, can perform the essential functions of the job. So, and we're gonna continue to break everything down so that you can digest it in like just bite-sized pieces. And so with that, we're gonna also talk about what is the definition of disability under the ADA. So under the ADA, the definition of disability is a person who has a physical or mental impairment that substantially limits one or more major life activities, or a person who has a history or record of such impairment, or a person who is perceived by others as having such an impairment. We're going to talk a little bit more about this definition in a bit, but that's just to give you an idea of who would be covered under the ADA. Since it is the Americans with Disabilities Act, you do need to have a disability, or at least be perceived as having a disability, have a record of such a disability in order to be protected under the law. And so another, a term that's talked about in the definition of disability is a major life activity. And so the ADA defines a major life activity as related to one of five senses, ability to ambulate, and substantial cognitive deficiencies. Some examples of a major life activity, because like we said, the ADA says someone with a disability, they have to have a substantial limitation on a major life activity. So some examples of that are reading, interacting with others, speaking, learning, and thinking. And so does IDD, so intellectual and developmental disabilities, does that qualify under the ADA's definition? And so the answer is yes, as long as the disabilities substantially limit one or more major life activities, the person has a history or record of such impairment. And an example of that would be someone who's on SSI. That would mean that they have a history or record of having such an impairment. The person is perceived by others as having an impairment. So this means that actually the ADA does protect people who actually don't have disabilities. If it is perceived that they have a disability, then they would be protected by the law. And so you may be wondering, when I said that, if your employer, if they are covered by the ADA and you're covered as an employee, so there is actually a requirement that the company that you work for has at least 15 or more employees in order for the company to have to comply with the ADA. And so if you don't have protection under the ADA, then you're going to want to always look at what the state laws are. So in New Jersey, actually, we're lucky because just generally, when under federal law, you're given a certain amount of rights. The states, they have to give you at least that many rights, but they can give you more rights. And so that's exactly what New Jersey does when it comes to an anti-discrimination law. And actually, in a lot of other areas, New Jersey does give you more rights. And so the ADA state equivalent, which is the New Jersey law against discrimination, it protects you if there is at least one employee, actually. And actually, it also has a broader definition of disability. So we're going to go through that a little bit, but it provides more protection to more people than the ADA, which is why a lot of times lawyers might prefer to go to state court and file a lawsuit under the New Jersey law against discrimination, as opposed to in federal court under the Americans with Disabilities Act. And so, like I said, the definition of disability under the New Jersey law against discrimination, it is broader. And, it sounds complicated when you hear it, but I'm going to break it down in the next slide about what's important about this definition and why it is broader. But under the NJ-LAD, disability means physical or sensory disability, infirmity, malformation, or disfigurement, which prevents the typical exercise of any bodily or mental functions, or is demonstrable medically or psychologically by an accepted clinical or laboratory diagnostic techniques. Disability also means AIDS or HIV infection. Okay, so it's a lot of words there. Simply put, under the ADA, the disability does not need to result in a substantial limitation of a major life activity, which is what is, generally required under the ADA. But how is it the same as the ADA? So one of the ways that it's the same is that you still have to meet the job qualifications. You have to be able to perform the essential job functions. And so that's why, earlier I talked about how the ADA provides protections for someone who's a qualified person. So to be a qualified person, you not only have to have a disability, but you also have to be able to perform the essential job functions, and that's with or without a reasonable accommodation. And we're going to talk a little bit more about that, but just if you want to have it in your head for right now, if someone is has an intellectual disability, but if you break down instructions for them and you write it out for them, and that allows them to perform the essential job functions, then that's a qualified person. But if someone, even with a reasonable accommodation, cannot perform the essential job functions, then they would not be protected under the ADA. And so we're going to talk a lot about reasonable accommodations, how you could ask for them, and some of the laws surrounding reasonable accommodations. But it's something that you can ask for on the job, because that is what the purpose of the Americans with Disabilities Act is, the New Jersey law against discrimination. It's about leveling the playing field so that people who are disabled, not disabled, so that they could have, an equal chance to the extent possible to be able to be functioning members of society in the workplace. And so we're going to go through a case example, and just make sure I move this so that you can still see everything on the screen. Okay, well, I'll move it at the part that I'm reading it. Okay, actually that works. All right, so we have here Alessandro. He is a 47-year-old man with intellectual and or developmental disabilities. He works in a warehouse, and just like the little preview that I gave earlier, he needs instructions written out and recorded meetings to remember important information. Recently, he got disciplined because he misunderstood directions from a supervisor. Here we go. He misunderstood his supervisor's direction. He received no written instructions from his supervisor, and he was told he could no longer record meetings because his coworkers, they feel uncomfortable. And so you might be wondering with this example a few things. Is Alessandro protected under the law? What is the best way Alessandro could have protected himself? What should he do now? And did the employer break the law? And so what's really important is that when you're talking about a reasonable accommodation, and we're gonna go to the definition of it, and then I'll explain more. But a reasonable accommodation is any modification or change to the application or hiring process, to the job, to the way the job is done, or the work environment that allows a person with a disability who is qualified for the job to perform the essential functions of that job. And so when it comes to reasonable accommodations, it's really about an individual assessment. So if there's a situation where an employer says, well, I have a disability neutral policy. So everybody gets a 15-minute break in the morning, they get a 15-minute break in the afternoon, and I don't grant any other breaks to anybody. This is what the rule is, and it applies to everybody equally. So that's actually, that can be discriminatory, because the whole purpose of a reasonable accommodation is that it's supposed to be individual to that person. And so if you have that kind of policy, then you're not allowing for any kind of exception where you might have an employee who they can perform the essential job functions, but maybe they need an additional break because of a medical issue, or they need some other accommodation. And so that's something that is really important to think about when you're just on the job, and or if you're an employer, is that the accommodation has to be specific to you. And kind of the inspiration for this this case example a little bit was a case that I came across. It was a case that happened in federal court. We don't need to go through the name of it, but just as an example. The case involved a gentleman who had disabilities, and as a result, he had to get to work a little bit later. And he was a mold polisher. And so there were molds that were created out of metal, and they would go on, they would be created on a conveyor belt, and then they would need to be polished. And so his job was to polish it. So for many years, he worked there, and, he would get to work, 20 minutes late or whatnot. His normal work schedule began at 7. And so his company actually changed it so that punctuality, being on time, was an essential work function of the job. And so he ended up being let go as a result of this. And so originally the case was thrown out, but then, he was allowed to go forward with his lawsuit because it was something that really required an individualized assessment in terms of the reasonable accommodation. And also when it came to just, was this an essential job function? That ends up being a really hot button issue in these cases. We're going to talk about that a little bit more, but in this kind of situation, the court really looked at, well, he's polishing molds. It's not like his job is not dependent on timing. And so there was some information that, people who work on the conveyor belt, it is dependent on time. But for somebody like him, as long as he's there and able to polish them, didn't really matter if they were polished 15 minutes earlier or if they were polished 15 minutes later. As long as the job got done, that was fine. And, and also there, was a discussion by the court in this case about how it could be discrimination to say, well, this is the rule across the board for everyone, and we don't make an exception because, if we can't do it for one person, then if we can't do it for everyone, we can't do it for this one person. So that in itself is against what, the whole purpose of the law is. It is to create that special exception for the person with the disability so that they could perform the essential job functions. Of course, there are limitations on that, but just a little bit of a background. And, we'll discuss a little bit more about, Alessandro's case as we're going through the presentation. But like I said, I'm gonna provide you with information about how to request reasonable accommodation. And so that's something that is also an issue that you might think about in Alessandro's case. It's not really clear, but given that it seems like previously he was able to get these written instructions, he was able to record meetings, it seems like maybe he did ask for one, but it's actually a really case specific kind of thing that you need to look at, because and we'll discuss this a little bit more, even if he hadn't asked for one, if the employer noticed that he might have needed one, he still would need to provide that assistance to him with some limitations. And the other thing too is the fact that an accommodation was given to someone in the past, that's something that would also be looked at as important as well, about whether this is something that should be given under the law. And so requesting a reasonable accommodation, I think about the acronym FAIR, which an acronym is just an easy way just to remember the steps, because it is a word that has the letters that the letters that you need to know in order to know what this process is. And so here, remember the acronym or the word FAIR. So the number one thing that you need to do when you are wanting to request a reasonable accommodation is that you need to find the right person. So, and I actually have more notes about this topic that are should be included, I think, once the webinar is shared. If not, if anybody needs it, certainly our email is at the end, and I would be happy to send it to anyone. But you need to find out who the right person to speak to is in order to request the reasonable accommodation. It might just be your supervisor. There might be a specific person, like if you work for a state agency, there might be a specific person that you have to talk to. It just really depends. So the next in FAIR, because that was F, so this is A, is to ask for the accommodation in writing. It's not required for you to ask for the accommodation in writing, but it's something that's really recommended, because if there's ever, a lawsuit or there's like an issue in the future, if you have that in writing, that is just, it's more protective. It's just safer for you to have it in writing, that you have documentation of something in writing that shows that you asked for this accommodation. And, nowadays, everybody sends emails, people still send formal letters, but we send a lot of emails that we used to send as formal letters. And so you can send an email that, would be completely fine. And you don't need to use any kind of special words like reasonable accommodation. There's no magic language that you have to use. It just has to be enough information that the employer knows you have a disability and why you need help to do your job. And we're going to talk a little bit about what does it mean that the employer needs to know that you have a disability, because it's not exactly that, well, you have to say, well, I my name is X and I have X disability. You don't have to say, I'm Helen, I have an intellectual disability. So that is really a mistake that a lot of employees might make, or just thinking, okay, the letter has to say, I am requesting a reasonable accommodation, and that's also not the case. So we'll talk a little bit more about what is enough in terms of what you need to put in that kind of letter. And so once you make this request, you're going to enter into the I of FAIR, which is the interactive process. And, that sounds very fancy, but all it really is a meeting that you're going to have with your supervisor, where both sides are going to try to figure out what can be done to help you with your job. It's called interactive because it requires participation from both sides. And so, one party can't just, fold their hands and say, I'm not going to participate in this, and I have no suggestions. So the employee can't really tell the employer, well, look, you're my employer, you figure out what I need. It's really supposed to be about the two individuals working together to try to figure out a solution so that this individual can keep their job. And like I said, actually, it applies all throughout the employment process. It applies when you're interviewing. It applies when you have a conditional offer. It applies when you're on the job. It applies at all those stages. And so, if for instance, there's a job application and it requires you to write, an essay, and you have difficulty with writing, that's something that you can discuss, asking for a reasonable accommodation. Maybe filling out that written part is not an essential function. Maybe they can have a conversation with you about what it is that they're looking for. Maybe there's something else that can be done. And so that's why that process, that conversation is really important to try to figure out how can we make this work. So you don't have to explain exactly what you need, but you do have to explain what the problem is. And that can help you and your employer come up with a solution. And so if you have no idea what you need whatsoever, and the employer doesn't have any information to help you obtain what you need, then that might not necessarily really be a helpful process to trying to figure things out. And so that's why we're going to talk about Jan, and that's a resource that can help you figure out, what kind of accommodation might be helpful for you. And I have a link to the website in a slide that's coming up. The R of FAIR is reach out to your employer to follow up on the request. If you don't hear back, just follow up with your employer. And it might be that you need a medical note. And again, we'll talk about what that's going to require. It is not going to require your doctor to say that you have X condition. It's really limited the information that needs to be in that letter and what the employer is, would need to really consider that request. And, I say reach out also because if an employer doesn't respond in a way that is, responsive or quick enough, then, that could be discrimination under the law. That could be a failure to provide a reasonable accommodation, but just follow up with your employer and about, having that meeting and that process. So I mentioned the Ask Jan site, so askjan.org. It's a really fantastic site. It has resources for requesting a reasonable accommodation, including advice on how to structure a letter. There's actually a sample letter. And if you have, an intellectual developmental disability, you can go to the website and you can see some examples of some of the things that you can ask for from your employer. I mean, there are, just a whole list of disabilities and just, examples of things that you might be able to request from your employer. So I would definitely recommend checking that site out. And I talked about earlier about, how much information you have to provide. And so that's really in the category of disability disclosure. So is disclosure ever required? Do you have to say, that you have a disability? Or do you, have to tell your employer that, that you need a reasonable accommodation? What are the pros and cons about that? Is there a time when it might be a better idea or a worse idea? What are the things are implicated, or what are the things are just some issues that should be thought about? Because certainly, there's a risk if you ask for a reasonable accommodation at, an application process, even though you're allowed to do it under the ADA and under the NJ-LAD, obviously depending with the ADA and on the number of employees in the company, but there's a risk, right? Because, I think that there is obviously still a stigma, especially when it comes to individuals with intellectual and or developmental disabilities. And that's something that you really want to consider. If you're able to undergo the application, the interview process without a reasonable accommodation, you're going to need one later. I mean, maybe it's a better idea for you to think about once the job is, you're on the job, you have the job, you have some, additional protection, that might be where you want to request a reasonable accommodation. It really depends. But regardless, the employer does have to comply with the law. And if it's something that is legal for them to do, meaning that it's, you can do the job, you have a disability, it's a reasonable accommodation. And like I said, there are some limits on that, then it's something that the employer has to do. But those are just things to think about. And so do I have to tell my employer I have an intellectual and or developmental disability? And so pre-employment, an employer cannot request, but the employee can disclose if in need of a reasonable accommodation. Now that there's another exception to this, and that's really in a situation where, like, let's say the job is to be like a fighter pilot or something like that. So in that situation, they could ask about, maybe an essential function is that you've got to have, 20/20 vision. So they would be able to ask about that. So technically someone can say, well, they are asking if you have a disability by virtue of asking if you've got, 20/20 vision or whatnot. But they can, if it's related to, if it's job related, if it's consistent with business necessity, if it's something they're asking everybody, they can do that. And so once you have a conditional offer, there can be a medical examination that's required and disability related information can be sought. Again, it has to be job related. It has to be consistent with business necessity. And so let's say, for instance, part of the job is that you need to lift boxes. So they can ask you as part of a medical examination to lift boxes. And as long as they require everyone to do that, as long as it's job related, it generally wouldn't be something that would be considered discriminatory. Of course, this is all based on the specific case, but just to give you a general idea. And once you're hired, the employer can only request information about a disability if there's a reasonable basis. If the employee is unqualified, if they're in need of a reasonable accommodation, or if they pose a direct threat to the health or safety of the employees or others. So to touch more broadly on what I've mentioned before, how much do I need to tell my boss? You only need to disclose enough information for the employer to know that you were a person with a disability and how the disability affects the essential functions of the job. The employer may not ask questions that are unrelated to the functions of the job or relate to any kind of underlying condition the person has, apart from the need for an accommodation. And so if you don't need an accommodation, if there's like, your employer doesn't suspect you need one, then they have no right to ask about any kind of disability. You do not ever have to say, I have an intellectual disability, I have a developmental disability. You never need to say that. And you only have to say enough. So even, if you're writing a letter to your employer, you don't even need to say, well, I have a disability, I'm covered by the ADA. You could actually just say, I'm writing because I need some assistance. I have problems with reading and writing. And so I need X or I need Y to assist me with that. And so that would be enough to tell the employer that you have that need. I mean, they might want, some kind of medical documentation, but again, it's supposed to be very, very limited to only what the employer needs to know in order to give you that accommodation, to consider that accommodation. But if it's not related to an accommodation, you never need to say anything. So this is important too. You have to remember that an employer is not required to provide a reasonable accommodation if they don't know that there's a disability. If the disability is not obvious, if they don't have any other reason to know, then and you later say, well, this employer did not provide me with a reasonable accommodation, I want to file a lawsuit, then that would be what the employer would say in response to the lawsuit. They would say, well, I didn't even know this person had a disability. And so if they don't know, then they don't have to provide the reasonable accommodation. And of course, the employee still has to be able to perform the essential functions of the job. If the job requires that, you package 75 items in an hour and you can only package 20 items in an hour, then you're unable to perform the essential functions of the job. So unless there's something that can help you do that within that hour, then you would not be covered by the ADA. You would not be covered by the New Jersey law against discrimination. Another important thing, because I kept talking about just the limitations of the law, is that the employer does not have to provide a reasonable accommodation if doing so would cause an undue burden. And we're going to talk about that a little bit more. What does undue burden mean? It's like, it's legalese, what does that actually mean? But to go back to, and this is something that is a really critical issue, especially when it comes to a population that might have intellectual or developmental disabilities, whether that is you, whether that's a family member or a friend. So an employer, they may have a duty to ask the employee if the employee is in need of a reasonable accommodation. And so there's actually some information that the EEOC has provided on this topic, and that information is that if the employer has a reason to believe that someone may be in need of an accommodation, and it's something that relates to the mental function of that person. So if that person has an intellectual or developmental disability, and they could see that that person is struggling, then they may have an obligation to ask if the person needs a reasonable accommodation. And I said EEOC, and that is the U.S. Equal Opportunity, Equal Employment Opportunity is what I mean by EEOC, and that's really they have to do with the ADA. They're implicated when it comes to the ADA, and they're an enforcement agency. So you could actually file a complaint with the EEOC if you believe that your employer has discriminated against you under the ADA. And so they do provide some guidance and information about how the ADA, how those rules should be followed. And so regardless though, if it's a situation where an employer has reason to believe that someone has a disability, they can see like this person is like really slow on doing tasks, and but I've noticed if I give them written instructions, they're able to do it better. Then regardless, if they decide, okay, I might need to ask if this person needs an accommodation, any questions still have to be limited to finding out whether you are a person with a disability who needs an accommodation to perform that specific job. Again, if the disability has nothing to do with being able to do your job, they cannot ask you. Another important thing is confidentiality. And just go back to the Alessandro example, if you notice, it said that one of the reasons why the employer no longer wanted to allow him to record sessions is that, he said, well, it makes the other employees uncomfortable. And so that really begs the question, well, why are they even aware that, Alessandro made a request? And like I said, it's not really clear in that example, it's open to interpretation. But if he either asked for the accommodation, or the employer noticed that he was struggling, and because they're in a situation where someone there might be a mental an issue with regard to mental function, whether it is a diagnosis of mental illness, whether it's intellectual developmental disability, where the person might have a problem with their capacity to ask for the reasonable accommodation. And, so the employer in that situation, he said, well, let me ask and let me give him, let him record, let me write written instructions. Regardless of how that happened, it is completely inappropriate and unlawful for other employees to know about that accommodation, about that disability. And so under the ADA, employers must keep all of your medical information private or confidential. It has to be collected on a separate form and kept in a separate medical file apart from the employee's file. And only staff that need to know the medical information, direct supervisors, managers, should know the information. And so the peanut gallery, the rest of the employees who are upset that these meetings are being recorded, they're not supposed to even know that that is even an accommodation, and that there's someone with a disability. That is not information that they need to know. That is a violation of confidentiality. And so to talk about undue hardship and define that, because like I said, Alessandro, whether he asked for his own accommodation, whether the employee saw he needed one and gave him one, an accommodation only has to be provided in a situation where there's no undue hardship. So undue hardship, it basically means that, an employer who maybe for like financial reasons or maybe for some other reason related to undue hardship, they cannot provide the accommodation. And so in that kind of situation, they can deny it, and it wouldn't be discrimination if they can show it would be an undue hardship. But, there could be other sources of funding. So the employer really has to look at that. They have to decide it on an individual basis, and they have to see whether there's any other financial assistance available to help the employee. So an example of an agency that might be able to help financially would be the Division of Vocational Rehabilitation Services. And so before an employer can say, this is an undue hardship, this is going to cost us X amount of money in order to provide, whatever it is, in order to give the person a recorder, and in order for the supervisor to take the extra time to write out every instruction that he's provided. Well, I'm losing X amount of money and I can't afford to do that. Well, they have to first look at, is there an outside source of funding, whether they could really, before they could really say that. And again, that's something that is also really fact specific. And, an employer could get in trouble for saying that something is an undue hardship if it's not an undue hardship. And, that's really just dependent on the specific facts of the case. And so in terms of a time frame to file an ADA claim, So if you want to file an ADA claim, and that you first have to file a complaint with the EEOC, the Equal Employment Opportunity Commission. And that has to be within 300 days of the day that you were discriminated against. And what is going to happen from there is that once the investigation is completed, you're going to get what's called a right to sue letter. And once you get your right to sue letter, you have 90 days within which you have to file a lawsuit in federal court. If you don't file the lawsuit in federal court, you are going to be barred from, being able to file that lawsuit. In terms of the NJ LAD, how much time do you have to file an NJ LAD claim? So if you want to file in state court, you could actually just go straight to state court and file, as long as you file within the time frame. Like for instance, defamation in the state of New Jersey, you have a year to file that, but you're going to have 2 years to file an unlawful termination action generally. And so you don't have to go to the division, the New Jersey division on civil rights. You can, though. There are some people who they don't want to file a lawsuit. They only want to file in the New Jersey division on civil rights. And, there is a hearing there and there are decisions made. You can even get financial compensation there. And that's how you choose to handle things. You might be representing yourself. But if you do go and choose to file with the New Jersey division on civil rights, you've got to do that within 180 days from the date that you were discriminated against. And another thing that's important to know is that if there's a decision that there was no finding of discrimination, if that's what the New Jersey division on civil rights decides, you could be prevented from filing in state court. And so that's another reason why, if you're thinking of filing in state court, it might just be a better idea to just go and file at state court versus taking that risk that they'll decide that you don't have a case, and then you won't be able to file in state court. And so with that, I've made really excellent time. If anybody has any questions, I'm available for the next 20 minutes to answer questions. And we also have our information here at the end. If you have an individual case that you need advice on, you can reach out to us. We have a new fancy website, which okay, it's at the bottom. I'm blocking it. Okay, so we've got Disability Rights New Jersey, nj.org. That's our website. And I'm blocking it again from view. Hold on. Okay, well, I went to the next screen, but it's Disability Rights NJ.org is our new website. And actually, if you just search Disability Rights NJ, Disability Rights New Jersey, and I think even if you go to drnj.org, it'll direct you to our new website. And all of our contact information is also at the end. I skipped past it, but if anybody needs it and wants to put that in the chat, that's fine. And then we created this presentation with the New Jersey Council on Developmental Disabilities, and so their information is here as well. This webinar is going to be available on our website, and so you could always go back to it. And if you decide at a later time you have questions or you want to fill out an intake, then please, we are here to help people with disabilities. And with that, it looks like we might have some questions in the chat. Okay, no, we just have, okay, Mike gave the website and said, feel free to post your questions in the chat. All right, so if anybody wants to unmute themselves and ask a question, then I'm here. All right, Mike, I don't know if we don't have questions, if we should end early or something else.
Yeah, if everybody is comfortable with the information and not have any other questions, I would say we wrap up.
Unless you want to talk about what you do and how assistive technology could be a form of reasonable accommodation.
Sure. It could certainly be a form of reasonable accommodation. As I mentioned in the very beginning, I'm the director of the Richard West Assistive Technology Advocacy Center, which we are housed at Disability Rights New Jersey. And we are federally funded to provide support to New Jersey residents if they need assistive technology in order to be more independent. And that independence can be at work, at home, in the community, at school, whatever it might be. For the context of our webinar today, it would be employment. And we certainly can help by providing demonstrations of assistive technology, some examples of possible tools that could help an individual. We have a lending center where people can borrow devices. So if you're familiar with a piece of assistive technology and you would like to try it before you purchase it, we can certainly help you with that with some short-term loans, which are 3 weeks at a time, give you a chance to explore something and make sure that it's the right device for you. And then finally, we have a device reutilization program, which if you need any types of assistive technology, we have a reuse program through Goodwill Home Medical that collects devices from the community, refurbishes and repairs them, and puts them back out into the community for a significantly reduced rate. So that gives you just a quick little snapshot of the three main services that we do at ATAC. And if you're interested, our website, you can get to it from the Disability Rights New Jersey website that I put in the chat, or we have our own website, which is AT4NJ, and that's the number 4, so at4nj.org. And I'll put that one in the chat too.
So Mike, if somebody is in an employment situation and, they've asked for reasonable accommodation, but maybe they don't really know what options are out there or what they need, can they call you and say, this is what my diagnosis is? And of course, that's all kept confidential. Would you be able to help them with figuring out some assistive technology that could assist them?
Yeah, that's exactly what we do in an assistive technology demonstration. It is speaking with an individual, obviously all confidential, speaking with an individual and getting an understanding of their needs and their abilities. And then we're able to show them tools that are available out there and help them identify features of those tools that might be most beneficial for them. So it's really about matching their need to the technology. We can do that in person with people. We can do that virtually, whatever an individual is more comfortable with. Again, we're very, our funding allows us to be very broad in who we serve. Basically, the only thing that is a prerequisite is you have to be in New Jersey. And that's pretty much it. And then we can provide that support to help out.
Okay, all right. So if there aren't any questions, I don't have anything else.
Well, everyone, thank you for joining us today. If you registered, which you did if you were here, we have recorded the webinar and we will put this up on our Disability Rights NJ YouTube channel, and we will make sure that we forward a link to anyone who registered for the webinar today. So again, thanks for spending part of your afternoon with us. I appreciate it. Kathleen, thank you.
Thank you so much. Thank you, Mike. All right, bye-bye.
Okay.